Contracts. A contract is an agreement between two or more parties to enforce or by law. Because of unique aspects of insurance transactions, the general law of contracts had to be modified to fit the needs of insurance. D1. Elements of a legal contract. In order for insurance contracts to be legally binding, they must have four essential elements. 1. Agreement, offer and acceptance. 2. Consideration. 3. Competent parties. 4. Legal purpose. Offer and acceptance. There must be a definite offer by one party, and the other party must accept this offer in its exact terms. In insurance, the applicant usually makes the offer when submitting the application. Acceptance takes place when the insurer approves the application and insurer issues a policy. Consideration. The binding of force in a contract is the consideration. Consideration is something of value that each party gives to the other. The consideration in the part of the insured is the payment of premium and the representations made in the application. The consideration on the part of the insurer is the promise to pay in the event of loss. Competent parties. The parties to a contract must be capable of entering into a contract in the eyes of the law. Generally, the requirements are that both parties be of legal age, mentally competent to understand the contract, and not under the influence of drugs or alcohol. Legal purpose. The purpose of the contract must be legal and not against the public policy. To ensure legal purpose of a life insurance policy, for example, it must have both insurable interest and consent. A contract without a legal purpose is considered void and cannot be enforced by any party. D2. Characteristics of insurance contracts. In addition to required elements, insurance contracts have unique characteristics that distinguish them from other types of legal contracts. It is important to understand these features and how they affect parties to an insurance contract. Contract adhesion. A contract adhesion is prepared by one of the parties and accepted or rejected by the other party. Insurance policies are not drawn up through negotiations, and an insured has little to say about its provisions. In other words, insurance contracts are offered on a take it or leave it basis by an insurer. Any ambiguities in the contract will be settled in favor of the insured. Aleatory contract. Insurance contracts are aleatory, which means there is an exchange of unequal amount or values. The premium paid by the insured is small in relation to the amount that will be paid by the insurer in the event of loss. Personal contract. In general, an insurance contract is a personal contract because it's between the insurance company and the individual, because the company has a right to decide with who it will and will not to do business. The insurer cannot be changed to someone else without written consent of the insurer, nor can the owner transfer the contract to another person without the insurer's approval. Life insurance is an exception to this rule. A policy owner can transfer ownership to another person. However, the insurer must still be notified in writing. Unilateral contract. In unilateral contract, only one of the parties to the contract is legally bound to do anything. The insured makes no legally binding promises. However, an insurer is legally bound to pay losses covered by a policy in force. Conditional contract. As the name implies, a conditional contract requires that certain conditions must be met by the policy owner and the company in order for the contract to be executed and before each party fulfills its obligations. For example, the insured must pay the premium and provide proof of loss in order for the insurer to cover a claim. D3. Legal concept and interpretations affecting contracts. Indemnity. Indemnity is a provision in an insurance policy that states that in the event of loss, an insured or a beneficiary is permitted to collect only to the extent of the financial loss and is not allowed to gain financially because the existence of an insurance contract. The purpose of insurance is to restore but not let the insured or a beneficiary benefit from the loss. Utmost good faith. The principle of utmost good faith implies that there will no fraud, misrepresentation, or concealment between the parties, as it pertains to insurance policies. Both the insurer and insured must be able to rely on the other for relevant information. The insurer is expected to provide accurate information for the applications for insurance, and the insurer must clearly and truthfully describe the policy features and benefits and must not conceal or mislead the insured. Ambiguity in a contract of adhesion. Because only the insurance company has the right to draw up a contract, and the insured has to adhere the contract as issued, the counters have held that any ambiguity in the contract should be interpreted in favor of the insured. Representation and misrepresentation. Representations are statements believed to be true to the best of one's knowledge, but they are not guaranteed to be true. For insurance policies, representations are the answers that the insured gives to the questions on the insurance applications. Untrue statements on the application are considered misrepresentations and could void the contract. A material misrepresentation is a statement that, if it discovered, would alter the underwriting decision of the insurance company. Furthermore, if material misrepresentations are intentional, they are considered fraud. Warranty. A warranty is an absolute true statement upon which the validation of insurance policy depends. Branch of warranties can be considered grounds for voiding the policy in a return of premium. Because of such a strict definition, statements may be applicants for life and health insurance policies. For example, €1 are usually not considered warranties except in case of fraud. Recession, when an insurance applicant intentionally fails to communicate information with the insurer needs. The insurer has the right to cancel the policy even if the failure to communicate is discovered after the policy has been issued. This act is called recession, and the insurer is said to have rescinded the policy. Upon recession, the policy owner loses any rights to file a claim on the policy, and the insurer refunds all the money paid. Concealment is the legal term for the intentional withholding of information of a material fact that is crucial in making a decision. In insurance, concealment is the withholding of information by the applicant that will result in an imprecise underwriting decision. Concealment may void a policy. Fraud is the intentional misrepresentation or intentional concealment of a material fact used to induce another party to make the refrain from making a contract or to deceive or cheat a party. Fraud is grounds for voiding an insurance contract. Waiver and estoppel. Waiver is the voluntary act of relinquishing a legal right, calm, or privilege. Estoppel is a legal process that can be used to prevent a party to a contract from reasserting a right to or privilege after the right to or privilege has been waived. Estopping is a legal consequence of a waiver. Therefore, readability requirements. In the state of university, all insurance policy and contracts must be written in clear and coherent manner and use words with common and everyday means to facilitate readability. The text must be printed in at least 10-point type, except for specification pages, schedules, and tables.